Discrimination is not always obvious. It could be subtle, and there could be signs that the employee is unaware of. And then in hindsight, after they're terminated, they realize, wait a minute, I think I was discriminated against and fired unlawfully. It's not always obvious to the employee. Discrimination laws are designed to protect employees from discrimination in the workplace, being subjected to some adverse action simply because the employee is in this protected class. It is also a law that provides employees with an equal opportunity to employment. There is a difference between unfair treatment and illegal discrimination. So unfair treatment could be an employee feeling like they aren't being provided with the same opportunities as others, or that they're being disciplined. But discrimination is really targeting another person, an employee, on a basis of their protected characteristics. If we don't have that, then it might not be actionable in a case. Common subtle forms of discrimination could be offensive comments, derogatory dialogue. It could be being isolated and treated differently simply because of your protected class. There are a lot of subtle signs, and I think employees recognize them, but it's really important to determine whether it's severe and pervasive enough to be actionable. Discrimination can still happen even if someone doesn't say something openly discriminatory or offensive. It can happen in other ways as well, like failing to accommodate, failing to engage in an interactive process, isolating, singling somebody out because of their protected class, or firing someone because of a protected class, like age, getting rid of the older employees. That could be something that's discrimination and actionable in California law. Subtle signs that an employee might be treated differently because of their protected characteristics could be that they are subjected to disparate treatment, meaning they're treated differently than their coworkers. And it's obvious. There's obvious signs where they're being targeted, singled out, or just treated differently. That could be a discrimination case. And so we're looking at, why is that employee being singled out? Is it because of their recent disclosure that they're pregnant? Is it because of their race and they don't fit in with the majority? Is it because they're a woman in a male-dominant field? That's what we're looking for when we're talking about discrimination lawsuits. Some discrimination examples that people might overlook or dismiss at first could be that they're being laid off or their position is being eliminated. And they might feel like that is the truth and the employer is justified in that termination. But we really want to look for the motives. We really want to look at the fact pattern and see if there's something discriminatory going on. If that person's being pushed out because of a protected characteristic like age or gender or sex or sexual orientation, something like that could be illegal. Discrimination can still happen at the hiring phase as well as the promotion phase. So if a candidate is not selected specifically because of their protected characteristic, like age, race, national origin, sexual orientation, gender, pregnancy, and they weren't selected because of that, that could be a discrimination case as well. Discrimination can show up in association with pay, promotional opportunities, scheduling, preferential treatment. Those are all signs. If you aren't being provided with equal opportunity to employment because of your protected characteristic, that could be a discrimination lawsuit. Some workplace situations where employees often don't realize that their case might involve discrimination could be where they have a serious medical condition or they've disclosed a mental or physical disability. And after making that disclosure, the employer fails to engage them in an interactive process, dismisses their disclosure, and now they're being treated differently, they're fired, or they're not offered an accommodation. That could be a discrimination case. We often see employers try to disguise their discriminatory motives as a performance issue or a legitimate business decision. And truly, that's not the truth. They were acting with discriminatory motives. They were singling an employee out because of a protected characteristics and disclosure. And that excuse, it's simply pretext to cover up their discriminatory motives. Employers do not need to admit that there is discrimination for an employee to pursue an action. To the contrary, employers are often going to say, there was no discrimination. That's false. But truly, they're just covering up their motives. So it's very unlikely that an employer is ever going to admit to discrimination. If an employee is suddenly being micromanaged after disclosing a pregnancy or a medical condition, this could be signs that discrimination or retaliation are on the horizon. So it's important to look out for these signs because the employee might be being set up for adverse action like a demotion or unwarranted disciplinary action, and worst case scenario, a wrongful termination. Subtle discrimination can become wrongful termination later. Typically, what we see is an employee being targeted, singled out because of a protected characteristic, and then shortly thereafter, they're terminated, pushed out of their employment, specifically because of that protected characteristic. So there's a link between discrimination and wrongful termination in violation of public policy. There are forms of retaliation that overlap with discrimination lawsuits. So if an employee is retaliated because they've reported to HR, management, their boss, that they're being harassed or targeted because of a protected characteristic, and shortly thereafter making a complaint, they're suddenly fired, demoted, job duties are stripped away, they get a write-up. That could be retaliation for reporting discrimination in the workplace. One thing that employees misunderstand about discrimination laws is that there needs to be a protected characteristic involved. We're truly looking at what is protected under the law. And this could be a wide range of protected characteristics, anything from age, pregnancy, medical condition, mental physical disability, gender, sex, sexual orientation, race, national origin. There's a number of characteristics that are protected, and we need that to pursue a discrimination lawsuit. If an employee is feeling like they are experiencing subtle signs of discrimination in the workplace, they should start documenting what they're experiencing, what they're hearing, what they're going through. They should also make a complaint. You have the ability to voice your concerns. And if you feel like you're being a target of discrimination or harassment in the workplace, speak up, make a complaint, put it in writing, because that's the way you protect yourself ultimately. Evidence and documents that can help support a discrimination complaint include an actual complaint, a written complaint to HR, management, or the boss, emails, text messages. Anything written really helps an employee support their claims with evidence that they were subjected to discrimination in the workplace. When employees try to handle discrimination cases on their own, sometimes they may think that they are making a complaint verbally and it's enough. That could be a mistake because we want complaints in writing. We need a foundation to support this claim of discrimination, and oftentimes that's a written complaint. So we need documentation to prove this claim. And so one of the biggest mistakes we see is that the employee never made a complaint or didn't document the complaint. If it's not documented, the employer is going to say it never happened. If an employee suspects discrimination in the workplace, they should consult with an attorney, but they should also really talk to somebody internally. Voice your concerns, put it in writing, go to the boss, go to management, go to HR, see what happens next. Because if you're terminated shortly thereafter, that truly might be a discrimination lawsuit. Even if employees don't have direct proof or a smoking gun to support their discrimination case, they should still consult with an employment law attorney because it's important for an expert to look at the fact pattern, look at the potential claims, and evaluate the case to see whether or not it's actionable. What I would say to an employee who's afraid to speak up when they feel like they're being discriminated against and they fear retaliation is that you have a voice. You have a right to equal employment. And if you don't speak up, nobody else will. So if you want to be protected and you want to advocate your employee rights, don't be scared. Find the courage to speak up and disclose that you feel like you're a victim of discrimination in the workplace. My biggest piece of advice for employees that feel like something's not right at work is really take a look at what you're experiencing, document it, talk to a friend, talk to a mentor, and then even consult with an employment law attorney to get legal advice. Because if you feel like something's not right, your gut's probably right, and you might be a target of some unlawful activity like discrimination, harassment, or even retaliation. So talk to somebody.